My name is Rhiannon Edwards and I am a Senior Associate Solicitor in the Probate Litigation team here at Myerson Limited. Our team has a wealth of experience dealing with disputes arising after the death of a member of a farming family, and this video will give you an overview of some of the common features of disputes of this nature. The ownership structures and arrangements in the agricultural sector are complex and often based on informal agreements or a mutual understanding built on years, sometimes generations of farming. It is often not until after the death of a member of a farming partnership or the owner of farmland that the legal basis of the ownership of assets is clarified. Often, the legal reality of who owns what in terms of both the farming business and the farmland is vastly different from what those working with or related to the deceased had expected. For this reason, it is really important that owners of agricultural property take specialist advice when considering their wills. That said, probate disputes continue to be common in the agricultural sector. One of the most common types of claim we advise clients on in this area is called Proprietary or Promissory Estoppel. For an estoppel claim to be brought, we must be able to establish 1. That a promise was made, 2. That this promise was relied upon by the person bringing the claim, and 3. That this reliance caused a detriment. Finally, number 4, that it would be morally wrong for the person who made this promise to go back on it. A typical scenario where an estoppel claim would arise would be if a child was told by their parent that if they remained working on the family farm, that they would inherit the farm on the parent's death. Here is the promise. If the child agreed and worked on the farm on the basis that they would inherit it eventually, this is the reliance. The child may then work on the farm for a lower wage than they would have received had they left home and explored other job opportunities, or may opt to not undertake any further qualifications as they do not think that they will be necessary. Here we have a detriment. If all of these factors are present, the court would then have to consider whether it would be morally wrong to go back on the promise. If this scenario sounds familiar, or if you have any concerns regarding your position under a will dealing with agricultural assets, please do not hesitate to give our team a call on 0161 941 4000 or email us at lawyers@myerson.co.uk.